Good afternoon. I'm Ann Foster from Richards, Leighton & Finger, and we're here today to talk about the Revlon case. Dave, could you introduce yourself?
My name's Dave McBride. I'm a partner at Young, Conaway, Stargett & Taylor, and I was involved in the Revlon case. We represented the plaintiff in that case.
And could you just describe your background of a little bit what your career was like before you started to work on the Revlon case?
I went to law school at Emory, came to Delaware because my family was here. I really didn't have any plans of being a corporate lawyer or being anything other than a lawyer. I had no particular ambitions. But I wrote an article, unsolicited, for the Business Lawyer back in 1970, right after I passed the bar exam. And to the surprise of many people, that article got accepted to be published in the Business Lawyer about the Singer versus Magnavox case. And back in those days, I don't think there was anybody but Sam Arsht and Walt Stapleton who had published anything in the Business Lawyer from Delaware. So it got me a lot of attention, and people started sending me corporate work, especially after I switched from Byard, Brill, and Handelman to Young Conaway. And I had been doing actually I was working with Larry Hammermesh on the Phillips Petroleum case before Revlon came along. And before that, we were involved in a hostile case where I think we won the first and maybe the only up until Revlon case where the plaintiff had prevailed over a target board. Can't remember the name of the case now.
I noticed looking at your year for 1985 that you'd had the Edelman Phillips Petroleum opinion that had come out in February, so you'd already had a busy year before you got involved with this.
In fact, there's a story about the connection, at least the personal connection between Revlon and the Phillips Petroleum case. I was writing the briefs in the Revlon case, and Larry may remember this as well, but we were on an expedited schedule before the Delaware Supreme Court, and I'd been up all night one night and working through the day the next day, and we had filed our briefs at 5 o'clock, and then I think I was getting on, if it wasn't a red eye, it was a late night flight to California to defend depositions in the Phillips Petroleum case with, I think it was Ted Mervis and Paul Vizcarrondo and Larry. And when I got on the plane, uncharacteristically of me, this time I was flying first class, and so I got on the plane, sat down, I think it was next to Ted, and we had just filed our briefs in Revlon, and Ted turns to me and says, "I read your brief." I go, "Oh, really, already?" And he goes, "Yeah, it sucks." And so, but I had the last laugh, because I think we were out in California together when the opinion came down on the Revlon appeal. So, but maybe I'm confusing the appeal with the Chancery Court. In any event, it's a small world in Delaware.
It is. So tell me how you got involved in the Revlon case, because just to bring you back in time, first there was district court litigation that was filed by Revlon, and I don't think your firm was involved at all in the district court litigation. And then a few days later, there was the litigation filed in the Court of Chancery, and the original complaint was just filed by Skadden.
Yes.
And then several weeks later, there was an amended complaint, and your name was on it with others from your firm. So tell us what happened to get your firm involved with the case.
Well, my recollection was that Skadden contacted, I don't remember whether they contacted me or contacted Bruce or contacted both of us, but had decided that they had a conflict. And I can't remember whether they had decided they had a conflict and had to get out of the case, or they decided they had a conflict and needed sort of independent counsel to be on the team as well. But they had perceived they had some kind of conflict. And I remember going over to Skadden's offices to review documents that very first, it was a weekend, I think. And I had gone through all the documents and everything, and I remember a couple of the Skadden partners coming in the room And I basically said, boy, I think we've got a really good case here. And they looked at me like I was hallucinating and said, oh, well, we're glad you feel that way. But they had just, I think they had just lost the Moran case. And I think they were pessimistic about where the Delaware courts were going in terms of takeover litigation. Because there had been Unical and Moran, and so I think they thought that this was not a trend that was going to get reversed in Revlon.
And when you say that Skadden had a conflict, do you mean an issue conflict about the pill?
I don't, if I knew what the conflict was, I don't remember now. I don't know.
So by the time the amended complaint got involved in early October, had you been involved for a period of weeks by then, or did you get involved shortly before the amended complaint got filed?
I think we had been involved for some time before the amended complaint got filed, because I think we drafted the amended complaint, I think. It's my recollection.
And so the amended complaint had both Delaware firms on it. Is that something that you've done since? Have you had another situation where you had two Delaware firms signing a complaint?
Actually, I think we have, but I don't remember offhand. I just have a recollection that we've been involved with other Delaware firms, maybe even with Skadden, because I think Skadden did come to Bruce Stargett on occasion when they maybe had an issue conflict or some kind of conflict that required sort of independent counsel getting involved.
So once the amended complaint got filed and things were really moving in terms of Pantry Pride continued to raise what it was willing to pay and so on, you had a deposition schedule that got put into place, and my understanding is that you were very involved in the depositions.
Yeah, but before that, I remember, and I looked in the opinions and I didn't see it, and I didn't have time to go back through our file to remember exactly what had happened. But I know Steve Lamb and I went over on, I think, 2 occasions, maybe even 3, where we tried to get Vice Chancellor Walsh, I don't think he was yet Justice Walsh, but maybe he had just become Justice Walsh and was sitting by special designation. But we tried to get Justice Walsh to schedule a preliminary injunction application. And we'd go over, and the Wachtel team would be there, and we would argue that things have gotten to the point now where we need relief. We want to go forward with our offer. And Justice Walsh kept putting us off and saying, well, I don't think we're quite there yet. I don't think we need to expedite things to a preliminary injunction quite yet. And one of the last times we were there, I think it was like on a Thursday or Friday, so it was either the second or third time, and we made our pitch again that we needed to schedule a preliminary injunction, and we made the argument that we don't know what's going to happen, but something's going to happen, and we should put a schedule in place so that we can address it at a preliminary injunction. We basically made the argument, we don't know what they're going to do, but they're going to do something, and we ought to schedule a preliminary injunction. And Justice Walsh declined to do that. And one of the Wachtel lawyers, at least to my recollection of it, made the statement that nothing was going to happen. And then it turned out, maybe Larry can correct me or not, but and it turned out that something did happen that weekend. We went in for a temporary restraining order on, I think we filed it on Sunday and was heard on a Monday. But there was a little bit of bad blood between, it may have been what was said on that Monday about what we said, the Wachtel lawyer said on Friday, that he said he didn't say that, and took some umbrage at how we characterized his statement.
And I'm going to ask you about that some more in a moment. Just to give you some dates to take you back in time, On Saturday, October the 12th, the Revlon board met, and that's where they agreed to the lockup. And as I understand it, depositions had been occurring in the week leading up to that. And I've heard that on the Friday, Bergerac and Perlman were both being deposed, and both of those depositions were terminated after a very short period of time. So, what do you remember about the depositions? Did you happen to take Judge Rifkin's deposition?
I did take Judge Rifkin's deposition, but I thought that occurred after the TRO was entered.
I think it was the week before.
Yeah, was it the week before?
Yes.
Really? Jeez.
So Judge Rifkin, of course, later on in connection with the preliminary injunction, put in, this 3/4 of an inch thick affidavit, the likes of which I don't know that I've ever seen anything quite like it.
The brief-a-David.
It did appear to be like a brief-a-David. So what do you remember about his deposition?
Well, I may be misremembering because I thought this occurred, I thought I took his deposition after the TRO was granted, and I thought after the lockup deal had been entered into. And I have to go back and find the transcript, but I remember going through the minutes that Wachtell Lipton had prepared for the board meeting. And I thought the lockup had already been granted because I remember asking Judge Rifkin something like, our client had said that they would top any offer that Forsman Little made by a quarter. And so I remember asking if he knew that, and he said he did, and I said, well, then why, before you entered into the agreement, which I thought was the lockup agreement with Forsman Little, did you not come back to MacAndrews and Forbes or Pantry Pride and ask if they would top the existing offer? And my recollection is he said, because we knew they would. And then he volunteered that, basically asked me the question, I think, to the effect that if you thought you could tear down St. Patrick's Cathedral and sell it off in parts, and you could sell it, and the parts would earn more than the cathedral was worth together, would you do that? Or something along those lines. And I remember either thinking or saying, are you equating Revlon to St. Patrick's Cathedral? But it was the argument about not wanting to bust up the enterprise, or not wanting to bust up the corporation. Of course, if Forsman Little was already signed up, they had already made the decision to, in effect, bust up Revlon.
And Judge Rifkin was later quoted as saying, now let's talk about the notes for a moment. He was later quoted as saying that the Revlon board thought they had a moral obligation to the note holders. Was that something that came up at all in his deposition?
Oh, I'm sure we did, and I remember that we made much of. I think I took Bergerac's deposition. I remember chasing Herb Wachtell and a witness out into the hallway. They took a break and they went out into the hallway, and I went out in the hallway after them because I thought they were going to be discussing deposition testimony. And I was saying, you can't talk to the witness about substance of his testimony. I remember Herb just brushing me aside like I didn't even exist. Nothing ever came of it, but I remember making much of the fact that directors had brought in personal counsel, that they were concerned enough about their potential personal liability to the note holders that they had brought in personal counsel to at least one of the board meetings. And now I don't know whether that was the original deal with Forsman or the lockup deal. But
I think they did it both times because Gil was saying he thought that they were there for both the October 3rd original deal and then the October 12th.
Yeah. Now, so maybe I've got it wrong in terms of when, I must have it wrong in terms of when the depositions occurred. I could have sworn that it was after the TRO. Did we have any depositions after the TRO?
You did not have any depositions after the TRO.
Wow.
Because, well,
Shows you how bad your memory can be, doesn't
well,
it?
the time, it all unfolded at a very high rate of speed when it all started to happen. Another thing about Judge Rifkin I wanted to ask you about is Judge Rifkin was obviously on the board of MacAndrews and Forbes and on the board of Revlon, and was on both boards until August 18th, when he finally resigned from MacAndrews and Forbes. Was that something that you talked about with him during his deposition?
I'm not sure that I even knew that. I don't remember it.
It's a fact that today seems so remarkable, but there's not a single participant in the matter so far who looks back and remembers anyone making a fuss about it.
Yeah, I don't remember making a fuss about it, and I don't even remember whether I knew about it or not. But in some sense, there was a sort of gentlemanly ethic that seemed, at least it seemed to me, that prevailed at times, because I thought, on occasion, I thought we could be more aggressive than we were, and I thought we were being gentle with people sometimes, because I thought they didn't want to alienate someone that they actually had a personal or social relationship with.
So in terms of what happened timing-wise, the Revlon board met on a Saturday, October the 12th. They approved the lockup. I guess it wasn't announced until the next day, Sunday the 13th, which is when you all found out about it. And,
Right.
Probably had your papers going. And then on Monday the 14th, you moved for a TRO.
Right.
And so tell me about what you remember about, representations that were made to you guys about the assets and what was going to happen, in terms of the status quo.
Well, I'm questioning my recollection now. I wish I'd gone back and I would have had to spend days going
Here's
through
your
the file.
affidavit, if that'll help you.
Oh, oh boy! Now I'm really going to be cross-examined.
Not at all. I just
No,
thought
I'm
it would help
kidding.
you.
I'm
Yeah,
kidding.
but you put in, because there weren't depositions after they had that meeting on the 12th. You had to put in that affidavit describing the different documents and what was going to happen that you needed to stop on behalf of your client, so that the court would have something to consider for the TRO.
But we didn't take depositions after the TRO?
No, because the TRO hearing was on Tuesday the 15th, and the preliminary injunction hearing was Friday the 18th.
Wow.
So you spent the week drafting
Writing
briefs.
papers, huh? Oh, man, I can't believe it. Well, I have a vague recollection of that Sunday. I forget who saw it, who saw the newspaper article, but I think I got a call from Bruce saying, get in the office, if I wasn't already there, and preparing the papers. The only thing I remember about the TRO hearing, and maybe Larry will remember this or again correct me because my memory's flawed here. So I remember Bruce Stargett, I thought this was one of the most effective arguments I'd ever seen, that we were the movement, but Bruce got up and basically, I think, told the court what had happened over the weekend, and then turned to Larry and said, Mr. Hammermish can explain why this happened or what happened or something, and then Bruce just sat down. And I thought only Bruce Stargett would have the confidence or whatever it took to make an application for a TRO and then make an opening argument that was not very long and basically turned it over to the other side.
Because as I understand it, you were under the impression that no steps had been taken to put the assets in escrow, and then when you got to the hearing, you found out that wasn't true. They'd already done it.
Yeah, and I'm not sure that we knew that at the start of the hearing even. I don't know. I don't remember it that well.
But it was the first time the court found out also was during the hearing.
Yeah,
So then the TRO got entered.
yeah.
And then you had 3 days of working on the briefs before the Friday preliminary injunction hearing. So
Wow.
So up to the date of the hearing, at that point, the Pantry Pride offer was $56.25. And Forstmann Little was $57.25. So going into the hearing, at least in terms of putting aside time value of money and
Right.
quality of financing and all those other things that we would always talk about, facially the Forstmann Little deal was higher. So what did you think was going to happen at the hearing, in terms of that part of things? Did you think that was going to be a serious problem?
I did. I thought, going into the hearing, and I'm not sure I was the prevailing, I may have been a minority view going into the hearing, but I thought we had a compelling case. But we although we were complaining about never having been given an opportunity to bid again, and we were arguing that we would have bid higher, we hadn't in fact made a bid. And so I had thought that when we went into the hearing that we would hear about that certainly from the other side, and I expected we would hear about it from the judge as well, because I didn't think the judge was going to enjoin the higher deal based on our argument that if given the chance we would have bid more, but hadn't yet bid more. So I remember, and I'm questioning my recollection about everything now since I was so wrong about the depositions. I remember Herb Wachtel making the argument that we hadn't made a higher offer yet. I think I remember him making some point about all you have to do is put a stamp on an envelope, put it in the mail or something, how inconsequential or how little would be involved in making the higher offer, but we hadn't done it. And I didn't understand enough at that time, until after the hearing, about the costs involved in making the higher offer. It was after we got out of the hearing where the judge, my recollection is that we thought the way Justice Walsh's, what he said in his demeanor at the hearing is that if we made a higher offer, we would get the preliminary injunction. And so I remember going back to Skadden's office and we called, I think it was Ron Perlman.
That's what I've heard from others.
Yeah, and the part I remember is something like, and I guess have others talked about this
They have,
conversation?
yes.
So I'm not divulging any privileged thing that hasn't already been divulged. Well, my recollection was that he asked, well, how much would it cost? What would the financing fees be in order to up our offer? And my recollection, it was, maybe I'm not right about this, my recollection, it was like $100 million or some number like that. Is that what
that I've not heard anyone say. Yeah.
All I remember is when I heard the number, I thought, oh my God, no wonder we didn't up our offer. And then someone said, oh, that's nothing. Okay, we'll do it. And I thought, that amount of money, whatever amount of money it was, it seemed like a lot of money to me at the time. And I was sort of surprised as how easily everybody said, oh, no problem, we'll pay that.
As I understand it, there were people who were leaving the courtroom every 15 minutes or so to call in reports to your client.
Yeah.
So that by the time you guys came out of court and gave your report,
They'd
already heard
knew,
a lot about it.
Yeah, that's not surprising. Hope they weren't using cell phones.
I'm confident they were not. I'm sure they were using payphones as one had to do at the time.
Yeah.
So what else do you remember about the preliminary injunction hearing?
Boy, I think I remember Bruce and someone from Skadden making the argument. But not much more than what I've just recounted.
So that was Friday the 18th. The 23rd, the opinion came out.
Okay.
So then between the 23rd and the 31st,
Was
the injunction comes out, there's a stay, there's the interlocutory appeal, which is certified, it gets accepted the 25th, and then the 28th and 29th, each day you filed a brief. simultaneous opening, simultaneous
yeah.
reply. That's probably when you then got on the plane. And then the 31st was the oral argument in the Supreme Court, and then the next day the Supreme Court ruled.
Yeah. And I
So you were, it sounds like you were out of state for the Supreme Court
I
argument.
don't think I was at the Supreme Court argument. I don't think. If you have a transcript and I'm not on there, that would.
I have a transcript, but actually there's nobody listed on
Listed?
this transcript from Young Conaway, so.
Huh. Now,
Don't
I
know.
thought I remembered Justice Moore giving Bruce Stargett a hard time during that argument. But, well, that's why I wasn't there. I'm pretty sure. I'm not pretty sure about anything now, but I think I was out in California at the time on a Phillips Petroleum deposition.
But you were very involved in writing the briefs for the appeal, so tell me what you remember about what you thought your best arguments were on appeal.
Well, I remember at the very beginning of the case thinking that after having, Justice Walsh in particular, after having taken the step, which was then a somewhat controversial and adventurous step of allowing for the creation of this new instrument, the poison pill, that the court might be looking for an opportunity to demonstrate how the existence of a poison pill didn't necessarily give the board freedom just to do anything it wanted, or even freedom to do what might arguably be sustainable under the business judgment rule as opposed to unical. And I remember, I haven't reread the briefs, I wish I had now. I remember not thinking that the court, that our ab initio attack on the rights plan was, I thought, not going to go anywhere. For obvious reasons, they just sustained the existence of a rights plan, and I didn't think that putting a rights plan in place in response to an offer that they considered inadequate anybody was going to agree with the argument we were making on that. But I thought, to the extent that they had done anything to get in the way of the stockholders' ability to accept or reject our tender offer, that we had compelling arguments that they couldn't do that while at the same time facilitating another transaction.
And then what about the notes? You know, obviously Unical had just come out a few months earlier where there was the language about other
Yeah.
constituencies, and here there was something
Yeah.
to do with the notes and how they had treated the note holders. How did you think that would be received on appeal with the Supreme Court?
Well, I guess my reaction to the note holder argument had a couple of different reactions at the time. One is I thought that it gave us a little bit of, it gave us an argument about director interest. It gave us an argument that could challenge the loyalty of the directors in some fashion that otherwise we didn't have too much. Although as I look in the footnote, that the Revlon board was dominated by insiders, so it looked like maybe I don't remember that part very accurately. So I thought we had a little bit of sex appeal in terms of director interest. But my recollection is that we had matched the note holder offer. In other words, we had said, we'll do the same for the note holders that Forsman Little has done. In light of that, I kind of thought, isn't it sort of moot now? I mean, who cares about the note holders? We're doing the same for the note holders. They can't use the note holders to justify the current treatment of us that we weren't willing to do for the note holders what Forsman Little was willing to do. So I was, I guess, a little surprised that the opinion went as far as it did in relying on the note holder situation, as opposed to just what I thought was sort of the more compelling argument is we're offering more money. You're selling the company for cash, any and all shares for cash, and we're offering more. I remember we cited, I think it was Wilmington Trust versus
Coulter?
Coulter, yeah. And that was our big precedent, was we were saying you can't sell the company to the low bidder. And I thought that was a pretty good argument, with or without the note holder problem. So I guess I was a little surprised the note holder became such a big deal.
And Justice Moore at the Supreme Court argument asked Gill about the auction point.
Yeah, I mean, I think, well, I will say that the development of the Revlon doctrine was surprising to me. Not only surprising, but I thought perhaps not a good turn in the law, but I'll get to that later maybe.
What do you think would have happened if the Revlon board had decided just to go to a sealed bid process rather than doing what it did? What do you think your client would have done?
You mean everybody, we're going to have an open auction. I don't remember what happened after the decision came down. I was trying to remember after I was just I just reread the opinion. That's all I did to refresh my recollection for this interview. But I don't remember what happened subsequent to the preliminary injunction, whether we completed our tender offer, whether there was an auction that was conducted. Because I know in QVC there was an auction that was conducted after we prevailed the preliminary injunction stage. I don't remember there being one here, but
before we get to the stage of the preliminary injunction hearing,
Yeah.
if the Revlon board had, gotten the offer from Forceman Little, the request for lockup, and had said, well, I think we're going to ask people for their best and final sealed bids, what do you think would have happened from your client's perspective?
I have no idea whether our client would have won that auction or not. I've often wondered how effective those auctions can be if even after the auction is concluded, one of the parties to the auction lobs in an even higher offer. What does the board do in that circumstance? In fact, I had a case like that. I don't remember how many years after Revlon it was, but I had a case where we weren't involved until the auction was done, but what happened was a company was put up for sale. There was an auction that was conducted just about as vigorously as you could imagine. No criticism could be made of the auction. My client won the auction. And merger agreement gets signed up, and there's a no shop, of course, but there's a fiduciary out. And one of the bidders comes to my client after the auction's done and the merger agreement's signed and says, well, congratulations on winning the auction. Now we want to talk to you about what portion of the company you're going to sell to us. And my client said, well, we're not going to sell any portion of the company to you. We won the auction, we want the whole company. They said, well, that's unfortunate, because if you won't sell what we want out of this company to us, then we're going to put in a higher offer. And they did. And we went in and tried to enjoin, I think it was originally just a TRO. It was before Chancellor Allen. We went in, I argued the TRO. We tried to enjoin the target from terminating the merger agreement based on the fiduciary out. And I made the argument that sustaining the merger agreement that was the product of a perfectly good auction, even in the face of a subsequent higher offer, was not a breach of fiduciary duty, that the board of directors at that point had no fiduciary duty to abandon the merger agreement when the merger agreement was the product of a fully and a well-done auction.
How'd that turn out for you?
It didn't make it. So that's why I say I don't know what would have happened if they had conducted an auction and we weren't the high bidder, but then lobbed in a later offer. Although I will say, in the case that I had, Chancellor Allen did something for us that allowed us to negotiate with the bidder that outbid our client. We increased our breakup fee like 4 times. So we had quite a substantial breakup fee. So we had enough leverage in that fight, even after, I think, not getting the TRO. And what actually persuaded Alan in that circumstance was, I made the argument that it wouldn't be a breach of fiduciary duty for the board to refuse to terminate the merger agreement because they had no fiduciary duty to terminate a deal once it's signed if the deal itself is not a product of a breach. And I thought Chancellor Allen sort of agreed with me, but then the lawyer from the other side got up and said, well, under our termination provision, we can terminate if we have a good faith belief that our fiduciary duty requires it. And I'm the lawyer for the target, and I'm telling you, we've advised our client that we have a good faith belief that their fiduciary duties require them to terminate the merger agreement, accept the higher offer. I said, I don't know of I'm trying to remember if there is a case where a well-conducted auction is subsequently jumped by a bidder who was involved in the first auction and just didn't make the highest bid.
So when the Supreme Court opinion came out, were you surprised about anything about the result?
No.
At that point, you thought you were going to win.
Yeah, I mean, I thought we were. I can remember sitting in Skadden's conference room that very first day thinking, I think we got a good case here. I thought it was pretty obvious that that Revlon was just determined not to sell to MacAndrews and Forbes, and I'm not exactly sure why. I do remember there being some banter about Revlon being such a wonderful company with such a high and expensive products and well-regarded, prestigious products, and how could Pantry Pride, a grocery store, take over Revlon? It was obscene. But it did seem to me right from the start they were just determined they weren't going to sell to Pantry Pride no matter what. And that's pretty much the way it played out.
So during the depositions, did you get any sense from the Revlon directors that they viewed your client as an upstart, someone that they didn't really want to sell to? Did that come through at all in the depositions?
Yeah, oh yeah. And I think it was Bergerac who, I think I took Bergerac's deposition. And I think I remember getting this disparaging of Pantry Pride and how Revlon was too important a company and too good a company to be taken over by the likes of a grocery store chain or something of that sort. And I guess that was pretty typical at that. Back in those days, anybody who was sort of on the hostile side of deals was considered something less than reputable just by virtue of being willing to do a hostile deal. In those days, it was still sort of poor form.
So did you think you would spend the next 30 plus years of your career talking about the Revlon opinion?
I did think it was an important case in the sense that, I've said this before about Unical. I thought Unical, before Unical, as you remember, there was an argument going on in the law about how to deal with tender offers. I mean, one argument treated tender offers as what they technically are, an offer by a potential purchaser to the stockholders to buy the stockholders' shares. If you treat a tender offer like that, then the board would typically have no role in making that decision. On the other hand, the tender offer from a business point of view was more like a merger. And in the context of mergers, boards had to approve the transaction before the stockholders could ever vote on them. So if the board didn't think it was a good deal, the stockholders had no right to entertain the merger. And I thought and so on the one hand, before Unical came out, those who, and I actually wrote a paper on this for PLI, I remember in 1982 or 83, those who represented bidders, as we did on several occasions, were arguing that the board should have no role. This is between the stockholders and somebody wants to buy their shares. and the directors shouldn't have any role in it. And on the company side, the argument was this is essentially like a merger, but it's any other business transaction, and the business judgment rules should apply. And I thought Unical was a compromise of those two positions, that it gave the board a role, and Moran then subsequently authorized the mechanism by which the board could exercise that role, the rights plan. It gave the board a role, but said that you don't have quite the same role you have in a merger, because you can't undertake a defensive technique that's preclusive or coercive, which to my mind was basically to say, in the final analysis, you must leave the decision to the shareholders, which was to say, basically, we're treating it like an offer to the shareholders. And in fact, Chancellor Allen made that distinction. I was in this case, I can't remember the name of it now, where he distinguished between the board's responsibility in responding to a merger proposal and the board's responsibility responding to a tender offer. And I remember I argued my client was making a merger proposal and instead of a tender offer. And I argued, you're handicapping yourself by structuring your deal as a merger as opposed to a tender offer, because the board's going to have more discretion as to how they respond because you've framed it as a merger. And that's exactly what Allen said. So I viewed Unical as sort of a compromise, and then Revlon would be the first opportunity the court really had to say, now how is this Unical standard going to operate in practice? Are we going to give the board sort of business judgment leeway in deciding what's reasonable, or are we going to require boards to ultimately leave it up to the stockholders when it comes down to especially if it comes down to just an all-cash offer for all shares, and it's 2 cash offers to the stockholders. But what I didn't expect was that Revlon would turn into this doctrine that when you're in Revlon land, you have to behave in a certain way, and when you're not in Revlon land, presumably you don't have to behave in this way. And it's sort of this binary universe where you're either in or you're out. And I remember writing an article about the Revlon case shortly after the Revlon case, arguing that this was an all-cash offer for all shares, and there were 2 competing cash offers for all shares. If you change it so that maybe there's stock in the mix, or if it's not for all shares, you could have all sorts of different variations where the result might be different. But I viewed it as sort of a spectrum from the all shares, all cash offer to maybe a merger of equals or something like that. And I didn't view it as sort of a binary Revlon land or not Revlon land. That development I never thought quite made a lot of sense. And in fact, I think it's true that if you look at Unical and Revlon together, Unical basically tells directors, if a tender offer is made and you decide to fight against it, we're going to subject your decision to heightened scrutiny. And oh, by the way, if an offer is made and you decide to accept it, we're going to subject your decision to heightened scrutiny. And I thought, well, how can it be both ways? And so to the extent that Corwin has eliminated Revlon as a heightened standard of scrutiny in cases where the stockholders have a fully informed vote, I think that's the right result, because I never thought there should be heightened scrutiny in Revlon land anyway. And I wrote an article about this. I tried to get it published, and actually Chancellor Allen tried to get it published in the Business Lawyer, making that argument against the Revlon doctrine. And the Business Lawyer said, oh, we've already written there's been so many articles on Revlon, we don't want another Revlon article.
How long ago was that?
Oh, that was, well, Chancellor Allen must have been at Wachtell at the time. It was probably sometime in the middle 90s. It was after QVC. Yeah.
Is there anything else about your experience in the Revlon case that you'd like to tell us about today?
I think we've covered it, and I probably invented a few things along the way, so I hope it's not too inaccurate.
No, well, thanks very much.
Yeah, my pleasure. Thanks for including me in this historical review.